All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for argument in our civil number 17-362, Ryan HANFELDER versus GEICO Indemnity. Each side will have 20 minutes in which to argue its position. Appellant may reserve a portion of that time for rebuttal argument. Counsel, you need to keep track of that time for yourself. We've read the briefs and conference this case. We're familiar with the facts and issues presented. Would each of you, as you begin your argument, identify yourself and the party you represent? Counsel for appellant may proceed. Thanks.
Ready? All right. Good morning, Your Honors. Justin Henry with the law firm of Levenbaum Trachtenberg on behalf of appellant Ryan HANFELDER. In this case, when the trial court substituted the term insurer for the definition of us in the contract, it ignored every canon of construction applicable to insurance contracts. Arizona law required the court to use the plain and ordinary meaning of the term us. The definition of insurer, if that is even a definition, is not the plain and ordinary meaning of that term. They were required to interpret it from the standpoint of one untrained in the law. Nobody untrained in the law would say that the definition of us in the contract is every insurer within the GEICO family of insurers.
Why not?
I'm sorry.
Why not?
Why would someone untrained in the law think that the term us?
Well, us, as I learned it, is first person plural. Why couldn't it refer to more than one entity?
Because the contract doesn't frame it in that manner. If you look at the contract in its entirety, us is clearly referring to GEICO indemnity only. When you look at one, the contract says we, which is us is defined in the dictionary as the objective form of we. It says we is the company named in the declarations page of the policy. The company named in the declaration of the policy is GEICO Indemnity Company and no other company. If you look at every other time that the policy uses the term us, it's clearly referring to GEICO Indemnity. Like, for example, if you look at the appendix, page 8, which is the selection rejection form for UM/UIM coverage, the only company it lists is GEICO Indemnity, and that sheet uses the term us as well. The privacy notice, which is at appendix 14 and 15, also uses the term us, and more importantly, in that same one, it talks about other GEICO Indemnity companies. You can't have the term us mean all GEICO Indemnity companies, and then the contract also refer to other GEICO Indemnity companies outside the term us. So it just doesn't make sense for all of those to be combined together. And the court, when it used the term, it only looked at us in its reference to the stacking provision that is at issue in this particular case. But you can't do that. You have to look at a contract in its entirety and as a whole. And even if you do look at it just in the terms of the anti-stacking provision, the court was required to construe it liberally in favor of coverage and with strict and narrow construction for exclusions and offsets. And this is clearly an exclusion and or an offset. And when you look at multiple packages or policies, that could apply to just GEICO Indemnity only. It doesn't have to apply to all GEICO family of insurers, because GEICO Indemnity sells multiple lines on multiple vehicles. So if he had 3 motorcycles on this policy, the language would clearly limit the stacking of coverage to the GEICO Indemnity motorcycles on the policy, and he'd have to pick one. But a strict and narrow construction doesn't mean that you apply it to every GEICO Indemnity company, especially when us is repeatedly defined in the policy, at least through implication, by limiting itself to GEICO Indemnity Company. You know, the trial court made a factual ruling that Ryan knew that that us applied to the family of GEICO insurers, and I think that was inappropriate. It did it based on the cover letter. The cover letter is not a part of the policy and is extrinsic evidence. You can't use extrinsic evidence to interpret a policy unless the policy language is ambiguous.
You don't think that the term "us" as used here is ambiguous? Because on the one hand, you're arguing that there's a rule of construction.
Sure.
Well, we don't apply rules of construction absent ambiguity either. So I think it either has to be clear or it has to be ambiguous if you want to invoke a rule of construction.
I would agree with you 100% on that, Judge Swan, and that's the problem with the way GEICO drafted this policy. If you look at State Farm versus Lindsay, our Supreme Court clearly said that if you are going to invoke anti-stacking language, it needs to be clear and unambiguous. And if we have to go into what Ryan knew, GEICO indemnity or GEICO family of insurers was the definition of us, and you're looking at what people knew to interpret what the meaning of a term is, then it's clearly ambiguous, and they violated Lindsay, and the anti-stacking language is void.
So you're claiming it is ambiguous?
I absolutely believe that it's ambiguous.
Well, then what's wrong with taking extrinsic evidence?
Because you can't even go that far because of State Farm versus Lindsay. State Farm versus Lindsay says that it has to be unambiguous. If it's an ambiguous term, it's not allowed. The Supreme Court in that particular case said the statute is not self-executing and that you have to add additional language to the policy in clear and unambiguous terms. If it's ambiguous, the Supreme Court's holding knocks it out, and that's exactly what happened in the Lindsay case, where the court said you didn't do enough. GEICO didn't do enough here, and you just can't get around the State Farm versus Lindsay holding. And if there is an argument that it's clear, which I don't think that there necessarily is, I think that all of the canons of construction say that it's limited to GEICO indemnity, not to the entire family of insurers.
Why do we have this statute, 259.01H?
To give insurers the option of whether to stack coverage or not.
But, I mean, couldn't they do that in the absence of the statute?
No, I don't think they could. You look at the Taylor versus Indemnity Company case, which says that any offsets or exclusions to UIM coverage that are not contained in the statute are prohibited. And so if the statute doesn't authorize an insurer to do this, they would not be allowed to preclude stacking under the Taylor versus Indemnity case. And the reason for that is UIM coverage is remedial, and it's supposed to protect insureds from underinsured motorists and from financially devastating motor vehicle collisions. And so this has to be there if our legislature has deemed it appropriate to preclude stacking in Arizona, which they clearly have, but they give insurers the option. It's not mandatory, as the Lindsay case notes. The language of the statute says may, and I think Judge Silver in the Delaney opinion, which was attached to the appendix, was absolutely correct when she said that the language of the statute in and of itself, because it's not self-executing, is irrelevant. You have to look at the language of the policy to determine what coverage was afforded to the insured by the insurance company. And here, GEICO Indemnity, at best, limited the anti-stacking preclusion to GEICO Indemnity only, not the GEICO family of insurers. In kind of dovetailing along on that, on the statute, the trial court held that the statute was incorporated into the policy. First off, that was a direct violation of the Lindsay case, which said it's not self-executed and it cannot be incorporated into the policy. More importantly, the language of the statute itself precludes that conclusion. The statute says, with respect to this particular clause saying that insurer includes every insurer within a group of insurers, says for purposes of this subsection. The entire purpose of the subsection is to make anti-stacking provisions optional. And so it doesn't make sense to have the legislature say, well, we're going to make this optional, but if you do invoke it, we're going to extend it to everybody without the legislature explicitly saying that that's what they intended to do. If that's what they wanted, that's what they would have said in the statute. And I think the easiest way to look at that is if you look at 225901A and B, where they talk about the selection rejection sheet for insureds when they're making a choice of whether to get UM/UIM coverage. And they specifically say, if you make this selection by one insured, it's valid for all insureds on the policy. So the legislature knows how to put language in the statute clearly where one selection makes it valid for everything else. And they didn't say that in subsection H of this statute. Instead, they specifically said, only for purposes of this, we're going to let you do this. We're going to give you the option to do this, but subject to the court's holding in Lindsay. And what's important to note is this language was added after Lindsay was decided. And so the legislature knew that Lindsay was out there and that the court said you need to add additional language, and yet they specifically said only for purposes of this subsection, rather than saying if this is invoked by an insurer, it's going to be valid for all insureds on the policy and for every group of insurers under common management for a group of insurers. But they didn't do that. And so it's still not a self-executing statute. They were required to put extra language in there, like State Farm does. In the Yeager opinion, you look at it, State Farm very explicitly adds it as part of their anti-stacking provision, which is what should happen and what other insurers do. GEICO elected not to. They drafted this contract. They're stuck with the language of it. So, there's no other questions. That's all I have. Thank you.
Good morning, Your Honors. May it please the Court, Ian Fisher from Lewis, Rocco, Rothgerber, Christie for GEICO Indemnity Company, and with me is my partner, Robert Schaefer. The us in the policy is not ambiguous. It has to be read in context. And the question here is, what does that last sentence of the statute mean, and how does that meaning impact a properly invoked anti-stacking provision in an insurance policy?
How can the language of a statute tell us what an unambiguous contract provision means?
Well, because the statute is automatically incorporated into the policy, and the way that occurs
What authority do you have for that statement?
Well, there's case law that says that statutes are automatically incorporated. I do not have the case in front of me, but we cited in our brief a case that says that the
It definitely wasn't cited
UIM
in Judge Brodman's minute entry, but you say it was cited in your brief?
Yes, Your Honor.
Okay.
And what we have here is a statute that has a permissive sentence where an insurance company is permitted to prohibit stacking, and then we have the last sentence of the statute is not permissive. There's no language in there that's permissive. It says
the last sentence of the statute says for purposes of this subsection, and then proceeds to define insurer. It doesn't say for purposes of the contract, or it doesn't say that the legislature is telling us how to read contracts that private parties draft.
For the fact that the revision of the statute comes after Lindsay, I think is an important fact, because what the revision of the statute, and the statute was revised in 1997, Lindsay was issued in 1995. Lindsay said a number of things. One of the things that Lindsay said was that you have to follow the language of the statute in order to invoke it. It also said that you can't remedy a failure to give a right to choose after the accident. You can't remedy a failure to give a right to choose in the policy after the accident if you've invoked the statute. So after Lindsay, 2 years later, the legislature passed this law, added two sentences to the statute. The fourth sentence allows insurers to give the insured a choice of policy after the accident, clearly rejecting that holding in Lindsay. And the last sentence gives direction about what happens when you comply with the permissive section of the statute. What happens when you comply with the permissive section of the statute is you invoke the anti-stacking clause for all insurers within a group of insurers under a common management. And it makes sense within the legislative scheme for insurers as well. Insurers can operate in the manner that GEICO operates. They have holding companies. These holding companies allow insurance companies to offer different risks, different levels of risks. For example, in this case, the fact that there's different holding companies allowed GEICO to offer a single insured, a motorcycle policy and a auto policy, policies with different risks. And what GEICO did here is follow what the legislature intended, which is if you're going to invoke anti-stacking, you're going to do so within our regulatory scheme. You're going to do so for your family of insurers.
You're going to do so clearly and unambiguously. I have to ask, I know this isn't your fault. You didn't write this policy. And I suspect if you had a first-year associate turn in this draft, you'd probably question that associate's future with the firm. But insurance policies tend to be written in a language other than English. And it amazes me because I don't know how many UIM cases or UM cases there have been in the appellate system, but it would seem at some point that insurance companies would want to just clearly write out what the policy provides. And to the extent they don't, it's beyond dispute that they're uniformly construed against the insurer. So do you have any idea, is there some advantage to insurance companies in using this cryptic language in drafting policies?
Well, I don't think the language is cryptic. The language follows the statute and invokes the anti-stacking clause.
Well, it actually, I mean, it doesn't. It could simply say, we hereby invoke the anti-stacking clause. There will be no stacking of insurance policies, no matter who they're with. This is the policy you've got. And if you want to choose a different policy, that's the only one you choose. If you were writing an agreement, if you were writing a settlement agreement, you certainly wouldn't write it like this. You probably wouldn't also emphasize the words you and yours for some unknown reason. But you would spell out, we are invoking this statute. All the protections of this statute apply. And the policy doesn't do that. I'm constantly befuddled by why we keep hearing these cases and insurers don't just write clear policies.
So you and your are emphasized in that provision because you and your are defined are specifically defined in the policy.
But us isn't emphasized, I assume, for the converse reason.
Right, us is not because it's not defined.
And why not?
Because adding language that you proposed, like we invoke the statute, may be sufficient, but that's not what the legislature required. What the legislature said is, when you invoke the statute for purposes of this subsection, you're invoking it for all insurers for every insurer within a group of insurers under a common management.
But the policy language doesn't invoke it. The policy language dances around it. There are notes of the statute that reverberate around this language, but it doesn't just clearly say we're invoking the statute, and that seems to me problematic. I don't know if it's because it's assumed that nobody will really read these things when they sign up for insurance, and maybe that's perceived as an advantage the more murky the policy is. But it would be so easy to invoke clearly the anti-stacking provision just by saying so.
Well, Lindsay and the statute, neither one of those requires specific language in order to invoke the statute, and the policy language does invoke the statute.
They require clear and unambiguous language.
Well, clear and unambiguous language, sure, but there's not specific language. It doesn't have to quote the statute. It doesn't have to say specific things. And GEICO, the provision that GEICO has in its policy, GEICO Indemnity has in its policy, says if separate policies or coverage with us are in effect for you, they may not be combined to increase the limit of liability.
So the drafters found it necessary to define the word you, which I can understand a prudent drafter would do that. They didn't find it necessary to draft the word us, and we're here today because one side claims us is ambiguous and one side claims it's not. Does that strike you as odd at all?
That one side would claim us as ambiguous. And one
No,
side
that
would
the
not.
drafters would choose to define you, but not choose to define us.
No, I don't. It does not strike me as odd because the drafters.
You would do that. If you were drafting this policy, you would say, take out the definition of us, we don't need it.
Well, I don't think it was a take out the definition of us. There isn't a definition
Why
of us.
bother writing one?
Because the drafters understood what the statute required, which is that they had to invoke the anti-stacking provision of the statute, and once they did, it would apply to every insurer within a group of insurers. Which the facts also support that. I mean, the cover letter, which is extrinsic evidence, provides the evidence that us is understood, that everybody knows that when you're buying policies from multiple GEICO entities, that you're buying policies from one holding company.
It doesn't even, though, I don't see that the language necessarily lends itself to the meaning you're describing, because it's perfectly conceivable that one would have multiple policies with the same entity, with the same us. And why couldn't one read it as saying, okay, I get it. If I have a bunch of policies with the same company, I can only invoke one. But if I buy a bunch of policies from different companies, us doesn't mean that. Why isn't that a perfectly reasonable reading?
Because it has to be read within the context that the legislature intended.
It has to be read in
has
the
to be read
context
in
that
the
who intended?
in which the legislature intended that statute be read.
So we expect people buying insurance policies to look them over and say, wait a second, I wonder if there's anything in the ARS that I should incorporate into this contract.
Well, I mean, we expect that people know the law, and that's a standard expectation of people. That we don't assume that because people are unaware of the law that they're exempt from it.
No, but you're arguing now that the law, which I think we all agree is not self-executing, so it doesn't provide a term in the contract. It merely permits the insurer to put a term in the contract. You're arguing that the law implies a standard of construction, and that consumers should be aware of that.
No, I don't believe it provides a standard of construction. What I'm saying is that the law is not having an anti-stacking provision is not self-executing, but when you have an anti-stacking provision, the statute provides guidance on what that means, and what that means is that anti-stacking provision applies to every insurer within a group of insurers under a common management.
Well, let me ask you the same question about simple draftsmanship. If the legislature had intended insurer to mean all companies in the contract, why did the legislature say for purposes of this subsection? It could have said for purposes of the contract.
Because what the legislature was saying when this subsection is invoked, for purposes of this subsection, it's being invoked for everybody. Now, in plaintiff's brief, the plaintiff offered an interpretation of the statute as if that last sentence was pure definitional, that it should be that the insurer in the third sentence of the statute should be replaced with the definition. But that wouldn't make sense. And the statute is definitional, but it's not definitional in the sense of insurer in this section means this. It's definitional in the sense that the legislature said it was, which is for purposes of this subsection, insurer includes. And so if you read if you strictly construe it as a definition that needs to be inserted into the third sentence, all it says is the statute, before you read the definition in there, before Lindsay said insurers may limit coverage. If you insert the definition, the statute says every insurer within a group of insurers may limit coverage. It doesn't say they may limit coverage amongst that group of insurers. It says every insurer may limit coverage, which would be redundant because the statute already allowed for that.
I'm not even sure what strict construction means, but a literal construction reads to me as though the legislature is expanding the anti-stacking right beyond a single entity to all entities in a group, and empowering insurers to create anti-stacking provisions within the group. Would you agree with that?
I do not. I think that what the statute says is that if you've invoked the third sentence of the statute, you get the group of insurers. And if the legislature had intended what you just proposed, they could have done that by putting a may in front of that last sentence. They could have done it by adding into the third sentence. They could have said,
well, they did put a may. They say the insurance may limit the coverage. And I think they left the insurers flexibility to limit the coverage any way they wanted within the bounds of the statute.
well, there's no may in that last sentence. And they very easily could have put a may, or they could have done what the Colorado legislature had done and put an or and said you could limit it for this insurance company or its affiliated entities. But they didn't do either. In that last sentence is a mandatory sentence. For purposes of this subsection, it includes. That last sentence isn't, for purposes of this subsection, you may include every insurer within a group of insurers for under a common management to prohibit stacking. It doesn't say that. It is a mandatory provision that has no permissive language attached to it.
I don't see that it's mandatory or permissive. It seems definitional. I don't know. I mean, it's not directory in any way. It's simply a definition.
It is a definition, but it's a definition that defines what happens when you've invoked an anti-stacking clause.
Well, okay.
I mean, for my 2 cents, it looks to me like it's an inclusive provision that's meant to define the group of policies that can be limited. So it's not directive, and it's clearly colored by the permissive language of the insurer may limit the coverage. I mean, it says insurer includes every insurer. That doesn't mean that every insurer has to participate in this anti-stacking scenario.
I mean, again, the sentence that has the permissive language is the third sentence. That sentence doesn't have any permissive language. That says that is a for purposes of clause. That doesn't say for purposes of you may, for purposes of you can. There isn't any.
I detect that the legislature may have the same frustration that I do with this sort of insurance haiku. When they asked for clear and unambiguous language, that should have been a cue to those drafting these policies to just come out and say it. If we're having this much discussion among rational people over what the term "us" means, isn't that a sign, pretty clear sign, that the term is ambiguous? And then don't we just default to our canons of construction for insurance contracts?
No, I don't think it is, because the canons of construction for an insurance contract say that you have to construe the contract against the insurer, but that's not what we have. You don't have to construe the statute against the insurer. You have to construe the statute in the context.
I don't think there's any argument that the statute is construed against the insurer. The statute is clearly designed to empower insurers to protect themselves. But the contract, which is insurers don't control directly how statutes are written, but they sure control how their policies are written. This is not a negotiated policy. So when the legislature says you can do this, but you have to do it unambiguously, that should be a wake-up call to people drafting insurance contracts, shouldn't it?
Well, the legislature didn't. It was the Supreme Court that said that you have to do it unambiguously. What the legislature did with that is add a provision to the statute after that said what happens when you do it unambiguously. And here, all that Lindsay said is you have to invoke anti-stacking clause unambiguously, and that is exactly what GEICO did. There is clearly an anti-stacking clause in this policy.
Yeah, there is, no question. But that anti-stacking could be read to apply to a number, or not apply to a number of different factual scenarios. The one I laid out was you buy multiple policies from the same company. I don't think there's any argument that the anti-stacking policy would apply. But how is a consumer necessarily to know who is in the group that is commonly managed?
Well,
Here today, I have no idea who GEICO manages.
but that's a sentence. So that's exactly why the legislature added this provision, because that is true for anybody. Plaintiff pointed to Yeager v. State Farm. In Yeager, the language is just the State Farm companies or companies under the State Farm entity. Maybe that's defined somewhere in the policy. I don't know. That's not included in the Yeager decision, but it certainly doesn't. That question that you just answered is not answered by including the GEICO entities in the policy. And the alternative would be for GEICO to have to list every entity that is under its umbrella. But what that would require is updating the policy every time those entities
Update
change.
policies all the time. I get emails from my insurer saying, "Here's your new policy language," and I delete them, just as most customers do. But they do update their policy language.
Well, that was not something that the legislature thought they were required to do in this situation, because the legislature understood that there are holding companies that insurers use to offer different insurance to different levels of risks, and that that's not required for an insurance company to update the policy with every holding company each time that changes. If there are no more questions, thank you, Your Honor.
Thank you, counsel. We're looking for the law.
No, you're
Thank you. Go ahead.
just a couple of points I wanted to address. There was a statement during the argument that the amendment to the statute in 1997 clearly rejected the holding of Lindsay. I don't agree with that at all. You look at what the legislature did when it amended the statute, and it did change and say, look, if you didn't give the insured the right to choose in your policy, then you can correct that with a 30-day curative letter. What they didn't do was say the exact same thing with respect to extending this optional anti-stacking provision to every insurer within a group of insurers. And if you actually look at the subsequent amendments, this subsection was initially, and that third sentence was initially for purposes of this section, and it was subsequently amended for purposes of this subsection in 1998, which clearly showed that the legislature only wanted to give insurers the right to extend it. And Judge Schwan, I think you were absolutely correct in that regard. They said, look, you want to do this, we're going to give you the option to do that, but you still need to do it in clear and unambiguous language, and they didn't do that. And when you're talking about the language of us here, GEICO repeatedly says, well, you have to read it in context. If you have to read something in context to understand what it means, it's an ambiguous definition, it's an ambiguous word. Plus, our Arizona law doesn't allow you to do that. You cannot say, well, for this one sentence in this 40-page contract, us means GEICO indemnity and every insured within the group of insureds. But the other 100 times us is used in the contract, it only means GEICO indemnity. You don't get to do that. The contract is read as a whole and not merely in context. And so we have a situation where they repeatedly use us throughout the entire contract, and it's clearly limited to GEICO indemnity. Who can you sue? You certainly can't sue the whole GEICO family of insurers if they didn't underwrite the policy for, say, a breach of contract. You can't give the whole family of insurers notice as required by the policy when it's using the term us. And so those are all clearly limited to GEICO indemnity, but they want this one time to be converted over to the whole family of insurers. You don't get to do that under Arizona law. They talk about the third sentence being incorporated into the policies. I haven't seen any authority, nor have I been able to locate any authority, and I know, Judge Bean, you asked for it, where a portion of a subsection is not incorporated, but the remainder of the subsection is incorporated. I've never seen that authority. I don't think it exists, and it doesn't make sense.
There are clearly cases where the law will be imported into a contract.
Absolutely.
But here we're having to deal with the Supreme Court's directive that this is not self-executing and has to be invoked with unambiguous language.
Exactly. The typical rule is Arizona law is incorporated into contracts, except when it's not, because that's what we do. and the Supreme Court in Lindsay said this one is not, and so we don't have to worry about that. And what we do have to do.
The trial court below specifically found that the statute was incorporated into the UIM coverage amendment, correct?
The trial court did, and it ignored and it violated the holding in Lindsay when it did that, and it was error for them to do that. That's what brings us here today, obviously. And so they shouldn't have done that because our Supreme Court said don't. I think that's all I have, unless there's any other questions from the panel. Thank you, Your Honor.
Counsel. We'll take the matter under advisement. We'll issue our decision in due course. We'll be at recess.